students here this afternoon for our graduate student panel. They will give back-to-back presentations. After the second presentation, the floor will be open for Q&A from the audience. Our first speaker, Desi Hanara, is an LLM candidate in public international law at Leiden University. She received her bachelor degree in law from Al-Azhar University in Cairo in 2011. She has extensive national and international work experience. Most recently, she was technical officer in the Human Rights Division of the ASEAN Secretariat from July 2012 through January of this year. Please join me in welcoming Desi Hanara.
Hi, good afternoon, everyone. I would like to thank University of Washington and Indonesian Consulate General in San Francisco for kindly inviting me to present my research. My study entitles Mainstreaming Human Rights in the Asian Judiciary, with a focus on the potential roles of Indonesian Constitutional Code in the context of Association of Asian Constitutional Code and Equivalent Institution, or AACC. Structure-wise, I will be covering the background as to why I was interested to undertake this study, and legal frameworks of the mandates of Indonesian Constitutional Code on human rights, the state of human rights protection in Asia, human rights mainstreaming in the judiciary, AACC's potential and the pertinent outcome of its third Congress, and also the ways forward. In terms of the background, my previous involvement with the work of ASEAN Intergovernmental Commission on Human Rights has brought me to a conclusion on main gaps in the promotion and protection of human rights in Asia and ASEAN in particular, namely the absence of binding human rights instrument and also enforcement and supervisory mechanism. On the other hand, I have also observed that there is lack of human rights mainstreaming into the works of the relevant stakeholders, which include the judiciary. On the other side, I have also seen promising development. First, from the side of AACC, where I have seen the emerging commitment of this institution on human rights, and it has the potential to actually house the mainstreaming project that we are talking about. And secondly, from the side of Indonesian Constitutional Code, I have also observed several potential roles for the court to actually take lead this process. First is the fact that the court has a mandate on human rights under the Constitution, and secondly, in light of the court's roles in the establishment and in the setting up of the direction of the AACC. And finally, is due to the commitment of Indonesia in terms of regional human rights cooperation. If we look at the drafting history of the ASEAN Charter, we can see how Indonesia was among the countries who actually defended the inclusion of human rights under the Charter. And Indonesia is also among the progressive countries that has contributed in leading and institutionalizing the key activities of the ASEAN Intergovernmental Commission on Human Rights. Let's now look at the legal framework of court's mandate on human rights. As the guardian of the Constitution, the Indonesian Constitutional Code is in a position to undertake any initiative that help advance the protection of human rights. And the Constitution guarantees human rights under Provision 8A, which consists of 10 articles. And these articles guarantee the rights of citizen and non-citizen, obligation of state and individual as the duty bearer, as well as limitation of rights and implementation of human rights. Indonesia has also ratified a number of binding and non-binding human rights instruments at the regional and international level. As you can see in the slide, these are the list of core human rights treaties and optional protocols that have been ratified by Indonesia. And being the member of the United Nations as well as the Association of Southeast Asian Nations, Indonesia is also bound by these two declarations, because these two declarations include some provisions that have been acknowledged or recognized as customary international law, and they have a jus cogens character which cannot be derogated. Now let's look at the state of legal protection of human rights in Asia. If we look at Asia, we can conclude that there has been no intergovernmental effort to set up regional human rights mechanism in Asia. Despite the robust development in international law at the international and regional level, we can perceive that Asian country has been a passive actor of this development, in a sense that they were only ratified all the instruments at the international level, and they were only participating as a state under reporting under the universal periodic review process. And we also notice the existence of several intergovernmental organizations in Asia, as you can see in the slide, but it is to be noted that these organizations only devoted little attention to human rights. And we have also seen several movements of the CSOs in terms of the development of regional mechanism in Asia as a whole. However, it is to be noted that this movement came from the CSO, and states were not involved in this process. Now let's look at the developments within the ASEAN context. The development of human rights mechanism in ASEAN started in 2009 when the ASEAN leaders established the ASEAN Intergovernmental Commission on Human Rights. And in 2012, the ASEAN leaders adopted the ASEAN Human Rights Declaration and Phnom Penh Statement on the adoption of ASEAN Human Rights Declaration. And this was the first standard-setting document in ASEAN which codified the basic rights and fundamental freedoms of ASEAN people. And there have been a number of activities undertaken to disseminate and implement the two documents, namely the dialogue with ASEAN Community Councils on the ASEAN Human Rights Declaration and the Phnom Penh Statement. And this was important because it was aimed to mainstream human rights into the work of the three community pillars of ASEAN. And there have also been two workshops on the development of ASEAN legal instrument on human rights. This process was led by the Philippines, and the second workshop was recently concluded in September. And this is also an important endeavor and event by the IJAR, because it marked as the first or initial step by the IJAR to embark on the process of the development of ASEAN legal instruments. And also there have been several progress in the development of specific ASEAN human rights instruments in the areas of commonly ratified human rights instruments, such as Convention on the Elimination of all discrimination of all, Convention on the Elimination of all form of discrimination against women, and also Convention on the Right of the Child, and also Convention on the Right of Persons with Disability. And this is greatly contributed by the work of relevant ASEAN sectoral bodies. And as an instance, there has been a good development in standard setting in the areas of right of persons with disability, which was evident through Bali Declaration on the enhancement of the role and participation of the persons with disability in the ASEAN community. And since 2015, the IJAR, as the Human Rights Commission, has also set up a task force on the mainstreaming of the right of persons with disability. And the mandate of this task force is to develop a regional guideline toward this endeavor. And ASEAN has also ratified conventions related to specific human rights issues, such as ASEAN Convention Against Trafficking in Persons and ASEAN Convention on Terrorism. And these two conventions was developed by relevant sectoral bodies and not by the Human Rights Commission. Having mentioned all the development, I think it is also important for us to note several concerns in the enhancement of human rights protection in Asia and ASEAN in particular. There are issues with regard to domestic political security concerns, internal circumstances, and the differing views on ASEAN values, and also the principle of non-interference and the ASEAN way remain to be a challenge. And available instruments are more of general political commitment by nature, and they are not enforced with monitoring or reporting procedure. And the TOR of the ARCA is actually silent with regard to the development of enforcement or supervisory mechanisms. And now let's discuss the importance of mainstreaming human rights into the work of judiciary. Why judiciary? Because they are the key stakeholder in the implementation of human rights at the domestic level. And the decision of judiciary set standard for future resolution of dispute between individual or between state and individual. And responsible judiciary is responsible in the realization of rule of law, democracy, and human rights. And the strengthening of judicial system and rule of law remains high in the Universal Development Agenda, which is evidenced under SDG 16. Under AACC, this institution was established in 2010, and this is an Asian regional forum for constitutional justice, and its mandate is to increase the exchange of information and experiences related to constitutional justice, and it also seeks to enhance cooperation and friendship between institutions exercising constitutional jurisdiction. As you can see in the slide, it has 16 members, and in terms of its activities, it has internal cooperation in form of international symposium, conferences, short courses, and also exchange of human resources. And externally, this institution works with Finnish Commission and Conference of Constitutional Jurisdiction of Africa, and it has convened 3 congresses in Seoul, Istanbul, and Bali. And the third congress was particularly important with our discussion, because the theme of this congress was the promotion and protection of citizens' constitutional rights. And it includes several important topics. One of them is the mechanism for the promotion and protection of citizens' constitutional rights. And this Congress resulted in a very important outcome, namely Bali Declaration on the Promotion and Protection of Citizens' Constitutional Rights. And this declaration enshrined, among others, the recognition of important collaboration of regional cooperation for the protection of democracy, the rule of law, and human rights. And it also reiterates the principle of judicial independence. Coming to my recommendation, which I will put it forward to Indonesian Constitutional Court. The first recommendation would be to encourage judicial independence. Why judicial independence? Because impartial and independent judiciary guarantees the constitutionally promised human rights, and it counters infringement of human rights from the other branch of government. And as an institution that has seek to establish system of justice, the United Nations has adopted this basic principle on the independence of judiciary. They are non-binding, but they serve as a standard model, which lawmakers are encouraged to adopt them in the respective constitution. So this principle requires, among others, the guarantee of judicial independence and adequate resources to enable appropriate performance of the judiciary, and also assurance from any inappropriate or unwarranted interference from judicial process. And to enhance the judicial independence, the Office of High Commissioner on Human Rights has appointed Mr. Diego Garcia Saya. He's from Peru. His mandate is to inquire into any substantial allegation transmitted to him and to report his conclusion and recommendation. And he is also supposed to identify ways and means to improve the judicial system, and he is to report regularly to United Nations Human Rights Council and also to UN General Assembly. And these are his modalities of work. He's supposed to send allegation letter and conduct country visit and also present annual thematic reports to Human Rights Council and also to General Assembly. This principle is also important when we are talking about judicial independence. This Bangalore principle on judicial conduct sets the standard for ethical conduct of judge. It serves as a guidance for the judge and provide framework for regulating judicial conduct by the judiciary. And it was designed to help relevant stakeholders to enhance their understanding and support to the judiciary. And the second recommendation is for the court to recommend to the board members of the ASCC to call upon on the development of binding human rights instruments as well as assess the feasibility of the establishment of ASEAN Human Rights Court. Learn from the other region, political instrument cannot actually establish a regional human rights court because it has to be established by a treaty concluded in accordance with the Vienna Convention on the Law of Treaty. And what are my views on the possible ASEAN Human Rights Convention? In my view, it has to include procedural and substantive rights because this approach was actually adopted by European Convention on Human Rights as well as Inter-American Convention on Human Rights. And the provision of substantive document will also allow ASEAN to adjust certain right, the content of certain right in line with the particularities of the region. And also I think it is important for the prospective convention to provide a mechanism that allow for change over time. As we have learned from the European process, the member states found that it was difficult to amend the European Convention on Human Rights on the basis that any amendment shall be made through the optional protocol. So the other view is to include admissibility criteria to avoid overlapping of jurisdiction with other institutions or mechanism, especially the UN mechanism where Asian countries are parties. And what are the prospects of Asian Human Rights Court? I would say that the prospect is quite positive in a sense that Asian countries are familiar with the binding form of adjudication in a variety of contexts. Some Asian countries went before the International Court of Justice to adjudicate a contentious case before the court, and they have also been involved in advisory opinion, and they went to International Tribunal on the Law of the Sea. And in the context of ASEAN, the protocol to the ASEAN Charter on Dispute Settlement Mechanism has also been adopted. And another significant development is that I found a political recognition from the Third Congress of the World Conference on Constitutional Justice, which reiterate the importance of promoting discussion on international cooperation in human rights, including the possibility of establishing a human rights to provide technical expertise and assistance for policymakers, judges, and lawyers. And this is actually consonant also with the areas of work intended for the ASCC, Permanent Secretariat of Research and Development. And if we were to implement this, I think cooperation with the OSCHR is also important because the OSCHR has developed a manual on human rights for judges, prosecutors, and lawyers, and this set comprehensive guidance in terms of the implementation of human rights at the domestic level. So to conclude my presentation, I contend that legal protection of human rights in Asia will only be guaranteed with binding human rights instruments enhanced by independent and human rights friendly judiciary and enforced by regional human rights court. And in light of the mandates of Indonesian Constitutional Court and its contribution to the ASCC, as well as Indonesia's commitment towards regional cooperation on human rights, I think it is really timely for the court to lead the follow-up of the outcome of the ASCC's Third Congress. Thank you for your attention.
Candidate from the Fletcher School of Law and Diplomacy at Tufts University. He's an awardee of the Indonesian Education Endowment Fund and received his BA from UW's Jackson School of International Studies. Yay. He has been involved in national and international development projects. This past summer, he interned in Jakarta for Citibank's Global Consumer Internship Program. And from 2014 to 2016, he was Outreach and Partnership Coordinator at the Center for Indonesian Strategic Development Institute in Jakarta, Indonesia. Please welcome Adi Sarosa.
Good afternoon. I hope everyone is still active. I know it's been a long day, but bear with me for like the next half an hour to maybe an hour and hopefully it'll be an interesting discussion. So thank you for the opportunity. As Shannon mentioned, I am a UW alumni, Jackson School alumni, so it's always good to be back here in Seattle. So right now I'm a Master of International Business candidate at the Fletcher School of Law and Diplomacy, and this research on sovereign wealth fund that I wish to share with you all today is really the initial part, the early stage of what I hope to be a larger research that will turn into my final project in the International Business Program. So I thought to make everything a little more clear, I would start with my background and how I got interested into this topic. So again, as mentioned, I did my undergraduate here at the University of Washington. I majored in international studies with a focus in development. After that, after undergraduate, I joined the Office of the President's Special Envoy for the Millennium Development Goals in Indonesia under Ibu Nila Muluk, who now is the Minister of Health for Indonesia. And that really gave me idea of how development in practice really works. So in undergrad, I learned about what development means, how it's like, what's the theory. This work in trying to implement the MDGs, the Millennium Development Goals in Indonesia, really gave me context on what it would look like in practice. And then after that, I joined a nonprofit called CISDI, the Center for Indonesia Strategic Development Initiative. And I was given the responsibility to lead the Outreach and Partnership Division, which was also really interesting because it gave me the chance to interact with corporations, government agencies, donor agencies, other nonprofits, and trying to understand what types of funding models, what types of financing models, private sector models can be applied in development. And that's after a couple years of doing that work, that's when I decided, I want to go back to school, really explore how private sector and private sector model, financing model can be applied in development. So that's where I decided to go back to school, do the International Business Program at Fletcher, and now for my final project, explore what role can a model like Sovereign Wealth Fund play in the Indonesian development. So here's for today's purpose, the outline of my research so far. So first I would go over a little bit of how development planning works in Indonesia, what's the economic outlook right now in Indonesia, and then I would go into a definition about what a sovereign wealth fund is. I realized, at least for me, coming into Fletcher, I didn't really know what a sovereign wealth fund really does, so I think it would be good to have like a common definition that really ties everything together of what it really is. And then we would go into the experiences of sovereign wealth funds in neighboring countries of Indonesia, specifically focusing on Temasek, which is Singapore's sovereign wealth fund, and Khazanah Berhad, which is Malaysia's sovereign wealth fund. So we'll start with the development context in Indonesia. Indonesia's development plan is really broken down into one long-term development plan, which is a 20-year interval, one medium-term development plan, which is broken down into four years interval, and then usually each administration would have a government action plan, depending on what are their election promises and all that. So right now, in 2017, we're in the midst of the 2005 to 2024 RPGP, or the long-term plan of Indonesia, which states that the plan aims to establish a country that is developed and self-reliant, just and democratic, and peaceful and united. And then that RPGP is broken down into 4 different RPGMN, or the medium long-term plan. Right now we're in the 3rd RPGMN of that, 2015-2019, which aims for a consolidation of development in comprehensive manner in all fields by emphasizing attainment of economic competitive through natural resources, human resources, and mastery of science and technology. The current administration, President Jokowi's administration's focus since coming to power 3 years ago, 2 to 3 years ago, has been to spur economic growth via cutting red tapes and fast-tracking infrastructure development projects in Indonesia. So here's a little snapshot of where Indonesia is economic-wise. So we can see that the country has a robust and strengthening real GDP growth at around 5%. Investment growth is around 4.8%. We have a low inflation rate per last month, September 2017, at 3.72%, and our currency is relatively stable. We have a narrow current account deficit at about 1% of GDP, and our balance of payment is actually showing a surplus of $4.5 billion US. Foreign direct investment, as per the last quarter of last year, 2016, showed a growth of 7.6% compared to the last quarter, and it was at $7.5 billion US. And then our GDP per capita is, we are, in 2015, it was recorded at $3,336 US, and we are aimed to relatively double that in the 10 years up to 2025. So what is a sovereign wealth fund really? Here's a definition by SWFI, which is Sovereign Wealth Fund Institute, a think tank that does work into providing common research and common definitions about the sovereign wealth funds in the world. They define it as a state-owned investment fund or entity that is commonly established from balance of payment surpluses, official foreign currency operations, the proceeds of privatization, governmental transfer payments, fiscal surpluses, and or receipts resulting from resource exports. So what I take from this, if I could put it in more general public language, it's really an entity where you have accumulated a large amount of funds that you can then invest in different purposes to generate additional income that then, depending on how that entity interacts with the government, can be used for additional source of income for the government. You can use for development projects. You can use it for multiple ways of using this entity. So here's a couple examples of more well-known sovereign wealth funds in the world. Norway has the Government Pension Fund of Norway. It's valued at $1 trillion US, and just to put that in context, that is relatively the size of Mexico's economy. Singapore has 2. They have Temasek, which I will go on deeper later in this presentation. And so Temasek manages assets to the amount of 180 billion US. And Singapore also has GIC, the Government Investment Corporation, which has double that amount of asset at 353.6 billion US. And then Japan also has the Government Pension Investment Fund, they're managing about 15.7 trillion US, which makes them the largest sovereign wealth funds by asset under management in the world. So I put here, it was really exacerbated after the 1998 Asian financial crisis and the 2008 financial crisis, because that's usually the time when economies are in dire need of cash, and these sovereign wealth funds usually are the only entities at that point of time who can inject large amounts of cash to keep systematically important banks from operating, key organizations from key economies from running. So that's really where where their role really came to be highlighted. Nonetheless, that also was a double-edged sword in a sense, because during this time, or maybe like a couple years after these financial crises, people start to look into the sovereign wealth funds and start to wonder how can we let these entities grow so much with such a large amount of fund without really any monitoring and really any accountability and transparency mechanism to oversee these institutions. So that's really when the sovereign wealth funds really got together, at least the big ones and systematically important ones really got together, and they came out with the Santiago Principles, which is their guiding ways of doing operations. The Santiago Principles states that it promotes transparency, good governance, accountability, and prudent investment practices whilst encouraging a more open dialogue and deeper understanding of sovereign wealth fund activities. So here are a quick snapshot of two sovereign wealth funds that I really want to highlight in comparison to a potential sovereign wealth fund in Indonesia. One is Temasek in Singapore. They were formed in 1974. The objective was to own and commercially manage investments and assets previously held by the Singaporean government. As I previously mentioned, they manage an asset to the amount of 180 billion US dollars, and they have been recorded to be able to provide 16% annual shareholder return, which makes them really revered. They're like a role model for many newer sovereign wealth funds around the world because of their financial success, how they're professionally managed, and their transparency. A couple of their portfolios, we can see that they have investments in AIA, an insurance company, AIA and Prudential are insurance company, DBS, Danamon, Standard Chartered, ICBC, China Construction Bank are in financial services. This is not an exhaustive list of what they invest in. Obviously, Temasek is very wide-ranging in their portfolio and what types of industry do they invest in. Khazanah Berhad in Malaysia was formed exactly 20 years after Temasek, and they actually stated, the government of Malaysia actually stated that Khazanah was formed modeling Temasek. They really want to mimic the success, the financial success, the professionally management method of Temasek, and the accountability and transparency of Temasek, and how they want and how the Malaysian government wants Khazanah Berhad to operate. The objective of Khazanah is to drive strategic industries and national initiatives for Malaysia's long-term interests. They manage about a quarter of what Temasek manages at 45 billion US dollars. Their portfolio here, what I highlight is CIMB, Malaysia Airline, Axiata are more national entities in national corporation, national brands in Malaysia. However, they are starting to expand their investment into the global platform. So they have put money into Alibaba and such. Even Axiata, if you are familiar with XL in Indonesia, one of the biggest telecommunication company, Axiata and CIMB actually also has entered the Indonesian market in the financial service by acquiring Niaga, one of the banks in Indonesia. So they are expanding their global outreach. Sovereign wealth fund models. In 2008, they came up with the Government Investment Unit. This was a task force / state-owned enterprise entity that was managed under the Ministry of Finance. The objective was to create macroeconomic stability and help promote economic growth by investing in a wide array of investment types. They can do equity, they can do debt, they can do direct investment into economies of foreign countries. Here are just a couple samples of their investments. They've worked together with Ant Global Partners, which, if you don't know, is a subsidiary of Alibaba, and they worked together to create the Indonesia Clean Tech Fund. They've created the Green Investment Fund, and they provided soft loans to PT PLN, which is the Indonesia State-owned Enterprise for Electricity. Nonetheless, throughout the years, they've been criticized for not being able to ensure macroeconomic stability via growth stabilization. And really, digging deeper into why that is so, it's really an unfair criticism because by regulation, the government, the GIU, Government Investment Unit, couldn't really operate freely. By legislation, they are a BLU, a Badan Layanan Usaha, which is essentially an Indonesian term for entities that they cannot incur any loss in any investment transaction. So if any of you do investment, that's actually not being able to generate any loss whatsoever in any investment transaction would be it will create a very impossible risk aversion attitude. So after a while in 2015, the GIU was dissolved, and then its asset was transferred into PT SMI, Sarana Multi Infrastructure, which is a state-owned enterprise to facilitate infrastructure financing, preparing projects, and providing advisory services to infrastructure projects across Indonesia. PT SMI works in conjunction of within this infrastructure development ecosystem. We see here that they were created in conjunction with IIF, the Indonesia Infrastructure Finance, and IIGF, the Indonesia Infrastructure Guarantee Fund. And this transfer from a GIU, a sovereign wealth fund-like model, to focusing solely on infrastructure development, this really is a reflection of the current administration, President Jokowi's administration's focus on infrastructure development. So if Indonesia does go forward with infrastructure or implementing a sovereign wealth fund in Indonesia, what would it look like? Obviously, it can take many forms, as we can see from earlier the examples of sovereign wealth funds, from Norway's pension fund to Temasek in Singapore to the pension fund in Japan. They all take very different forms and different ways of operating. But essentially, each of these successful sovereign wealth fund models exemplify these characteristics. So a sovereign wealth fund in Indonesia, if it does get implemented, would need to be able to consolidate capital, enough capital, large amounts of capital to be able to compete in the global market. They would need to have some level of independence from the government. They would have to be professionally managed. Ideally, it would have an executive team that would have extensive experience in either investment banking, asset management, or corporate finance and financial services as a larger industry. The sovereign wealth fund would need to have a clear positioning in relations to other actors in the development landscape. So if they are to be involved in the development of Indonesia, how would they interact with the Ministry of National Planning Agency, Bappenas? How would they interact with Ministry of Finance? How would they interact with Ministry of State-owned Enterprise and all that? And then finally, the sovereign wealth fund would need to have some sort of mechanism that would allow them to be transparent and accountable. Proponents of this proposal within the Indonesian government, Sri Mulyani, the Minister of Finance, and Bambang Brojonegoro, the Minister of National Planning, they are very big proponents of this super holding proposal, super holding company proposal. They really, and Rini Sumarno, the Minister of State-owned Enterprise, they all at one point or another have mentioned that this super holding company, their vision is that this would very much replica, if not exceed, whatever Temasek and Khazanah Berhad has done in the past. So, moving forward, how would we go about, or how would Indonesia go about going down the sovereign wealth fund path? Essentially, there's two questions that would need to be considered. One is they really need to make sure that sovereign wealth fund is the way to go. They want to really understand what a sovereign wealth fund is and whether or not this is the path to go. In my opinion, after doing this initial research, is that there are essentially three key areas why sovereign wealth fund would be a good idea for Indonesia. One, it creates an additional source of income for the national budget. As we've discussed, the current administration is very focused on infrastructure development, and the current infrastructure state right now in Indonesia is very far off from what the administration wants it to be. So there needs to be huge need for investment and huge need for funding to realize that infrastructure ambition. So a sovereign wealth fund would be able to provide that additional source of income. It's a stabilization for commodity export income. So I think I forgot to miss it earlier, or to explain it earlier, but the traditional sovereign wealth fund models are usually used by commodity exporting countries, like the Middle Eastern countries who export oil. And since oil prices is very fluctuative, having a sovereign wealth fund would be able to stabilize their income from those exports. So Indonesia, also being a very export-strong country, would have some benefit by having a sovereign wealth fund being able to stabilize that commodity export income. And finally, it will allow savings for a future generation. We've seen Norway do it, we've seen Japan do it. This sovereign wealth fund can be used as like a piggy bank, if you will, for that you would be able to use in the future for the younger generations to invest in their health and their education, for the elderly generation to invest in their pension funds and social welfare. Nonetheless, what would you need? The second question would be what needs to be considered further. You would have to think about, as I mentioned, relations to other government actors. Again, it will be how would they interact with the Ministry of Finance, Ministry of State and Enterprise, National Planning? Would they report directly to the government? So it would be all those questions would need to be clearly considered. They're really understand where is this entity would be positioned in the development planning moving forward. We would have to consider the level of independence. So would they want to be still managed, have partially managed by the government? Would they be fully independent and have just a purely independent executive body, but overseen by a board of director that would probably have some government representative in there? And the compositions of that board of directors would have to be discussed. Would it be pure government actors, or would it be representative from the private sector, nonprofit, and other? And then finally, the elephant in the room that would need to be considered. If you accumulate large amounts of funds into one entity, you would have to consider the risk of corruption. So in that, what I can really say is that whatever sovereign wealth fund or entity Indonesia does go forward with, they would really need to think hard and strong and tough about how would they ensure the accountability and transparency of this fund to ensure that we do not go down the same path that one MDB in Malaysia did with a misappropriation of funds. You would really need to think about how it would be accountable to the public and how it would be transparent. So with that, as I mentioned, this is still at a very early stage of my research, so I definitely welcome questions and discussions and suggestions on further areas that I can explore, even after this event today.
Wondering about, while you were talking about the role of sovereign wealth funds. It's particularly sort of prominent following the financial crises. And they can be used to inject funds into other sectors of the economy. I'm just wondering how, if there's a financial crisis and these are investing in companies, how there isn't risk to the pool in the fund itself.
Yeah, definitely, and that's something that these sovereign wealth funds have considered. I guess. In that case, that's where the importance of diversification of the portfolio really comes to play, because usually, in a lot of the crisis and financial crises, you wouldn't see everything go down at the same time, like all sectors across the board go down at the same time. So the idea of sovereign wealth fund is, and why they need to have large amounts of funds, large amounts of capital, is so they can have a diverse portfolio, invest in multiple different sectors. So if during a time of crisis, one of their portfolio goes down, they have another to back it up and essentially stabilize their return of their whole portfolio.
Thank you so much. Okay, thank you. Let's open it up to the audience for questions then. either Desi or Adi.
Thank you for your very interesting presentation for both speakers. My question goes to first to Desi. Yeah, Desi. We think that court is only one of the at least 3 different actors in the government. And how do you think that the idea of having that like a regional body concerning human rights will be possible to be implemented if the conditions of the domestic itself among the countries are so different? So how do you see that this idea will moving forward? That's the first question for. I think that's it for now.
Thank you.
Thank you for the question. I'm fully aware of what you are referring to, especially in the context of ASEAN. That's why I did not specify ASEAN, because I know how painful it is to reach agreement, especially human rights is quite sensitive and difficult issue in ASEAN. So I think the best way forward for the court is actually to proceed with the sub-regional cooperation. So perhaps it's not really sub-regional, but those countries who are advanced enough on human rights can come together and think about it. And I think the idea of working group or intersectoral committee that is to be set up is a good start, because then we can start with a zero draft of the convention, because any code or regional mechanism has to be established by the convention, and the negotiation can take place already from there, and then the member states who are willing to compromise on this regional body can actually state what are their limitations. And I also mentioned earlier that I think it is important to include substantive rights, because then it will give a certain degree of flexibility for the country as to what rights that they would like to include and what in line with the regional particularities. And yeah, so because I'm fully aware that the degree of human rights approach of each Asian member countries are different, and also I think as I have discussed earlier with Pak Ben also, I think it is one of Indonesian interests actually to proceed or to pursue a standardized approach on human rights in the region. But I think it is really tough. That's why I was opting for a sub-regional mechanism, and I did not specify any specific sub-regional organization. But I leave it open to any country who is willing to compromise, and maybe those countries who are advanced enough.
So thank you. So for the next hour, I'm going to do some presentation on the relevance of. No, I'm terrible at public speaking. Despite of the fact that I teach Indonesian language. I would like to conclude this event by thanking a lot of people who are responsible for the success of this event. So I would like to thank the Consul General, Pak Ardi Hermawan, for supporting University of Washington, the academic activities here. The supporting everything, helping us to bring scholars, and also, did I mention food? Yeah, so thank you very much. This will not happen without a large support from Consulate General Office. Also, I would like to thank my department. My department, Asian Languages and Literature, and also the Southeast Asian Center for a lot of support as well. Without which this will not happen. I am not a one-person show. And a special thank you actually for my co-organizer, Pak Bernard. The unfortunate, I don't, we planned this together. Actually, I don't do this all by myself. Pak Bernard did a lot of work and helped contacting and look for speakers, wonderful speakers that we have today, thanks to him. And also, I would like to thank our MCs and moderators, and also a lot of volunteers who, without me asking, they come and offer support. So what can I do to, what can I do? This is the true gotong royong principles in Indonesia. So, we work together to make things happen. That's the true gotong royong, and I feel very appreciative of the help. And also the support from staff support from centers. This is a personal juicy story, I think, if I may. We worked really hard late into the evening to prepare this, and we exchanged email. And at one point, as the true Indonesians, the conversation from organizing this and that always turned into the topic of durian and food. Yeah, so this is true Indonesian experience. And I also want to thank our friends who are outside there. It's from Indonesian Student Association, and they offer also help hauling the water and everything. Basically, a lot of help. And also, I also want to thank our wonderful speakers. They make me want to return to grad school again. Because I really don't know everything. I really feel that I'm sure we all benefit from this a lively discussion, and with that also from the audience for wonderful questions and for all the discussions. And with that, I would like to conclude and close this event with the hope that it will continue next year again. And it is a kode keras, Pak.